You would advise a client not to follow a federal district court opinion?
I would advise a client to follow court orders.
Would you ever advise a client not to follow a federal court of appeals decision?
I had the privilege of clerking on 2 federal courts of appeals.
Is that a yes or no?
Yes. I would advise them to follow the orders of courts of appeals.
How about Supreme Court opinion?
Yes, Senator, I would advise them to follow the Supreme Court's orders, as President Trump has been very clear.
Would you ever ignore the Supreme Court? Senator Kennedy just grilled 2 legal nominees, and their answers may surprise you. Get ready for a fiery exchange on court compliance, the APA, and the Chevron Doctrine all in one explosive Senate moment.
Thank you, Mr. Chairman. Gentlemen, I don't want to spend a lot of time on this, but I also don't want to debate how many lawyers can dance on the head of a pin. I think you understand where a lot of these questions are coming from. Mr. Gaiser, would you ever advise a client to ignore a federal district court opinion?
Thank you very much, Senator Kennedy. I would advise it.
Thank me. You can thank me by answering it.
I would advise a client on how best to comply with all lawful court orders.
Is that a yes or a no?
Yes, sir. That those orders are to be followed.
Mr. Woodward, let me ask you the same question. Would you ever advise a client not to follow a district court opinion?
No, Senator.
Would you ever advise a client not to abide by an opinion of the Federal Court of Appeals?
No, Senator. Again, it's difficult to answer in the hypothetical, but...
Would you ever advise a client not to follow an opinion by the United States Supreme Court?
No, Senator. As the President has been clear, he will follow all orders of the United States Supreme Court.
Tell me what I would need to do under the APA, the Administrative Procedures Act, if I want to change a current rule.
Well, Senator, as a senator, you would pass a law that would change the...
No. I don't want to play games here, Counsel. What would one have to do? What would the head of an agency have to do to overturn a current rule or regulation?
Well, Senator, I apologize. I know that there are many ways to do that, and I don't want to play games either. I want to answer the question.
That's fair.
There are many ways in which an agency can overturn a rule.
Well, you have to give notice, right?
As a general matter, yes, Senator.
Yeah. And you have to invite input, right?
As a general matter, yes, Senator.
Okay. And sometimes you have to hold a hearing, right?
Sometimes you do, Senator.
Yeah. Are there any exceptions to that under the Administrative Procedures Act?
Under the Administrative Procedures Act, I'm not aware of any exceptions, but there are exceptions under the law.
Okay. Are you familiar with the good cause exception to the Administrative Procedures Act?
Senator, I am vaguely familiar with that exception.
Okay. Do you know what it says?
No, Senator, I do not.
I understand. Here's what I'm driving at. Are you familiar with the Supreme Court's case called Loper Bright?
Senator, I am vaguely familiar with the Supreme Court's decision in Loper Bright.
The overturned Chevron Doctrine, right?
The Chevron deference doctrine, yes, Senator.
Okay. If there is a rule promulgated by a prior administration or even by a current administration that is in clear violation of the United States Supreme Court's pronouncement under Loper Bright, ruling unconstitutional the Chevron Doctrine, would it be possible, strike that, would it be prudent for the Justice Department to exercise authority under the good cause exception to the APA in the public interest and forego the the rule, the notice and comment.
So, Senator, thank you. I think I now understand your question. And that is I was alluding to the non-APA process. I mean, if a rule has been promulgated that is plainly unconstitutional, it absolutely would be appropriate for the Department of Justice to look at that rule and make a determination.
But my point is, you don't have to ignore the APA to do that, do you?
I would say it depends, but I take your point.
I mean, the APA provides an exception.
Senator John Kennedy came in with one goal: clarity. And in this Judiciary Committee hearing, he put nominees Gaiser and Woodward on the spot with one of the most important legal questions any lawyer can face. Would you ever advise a client to ignore a federal court order? Gaiser danced briefly, but Kennedy wasn't having it. He demanded a straight answer and eventually got a clear yes to following orders from district courts, appeals courts, and the Supreme Court. Then came the real heat: the APA. That's the Administrative Procedure Act, the law that governs how federal agencies make rules. Kennedy pushed Woodward on whether he even understood basic rulemaking steps like notice, comment, and the good cause exception, a legal backdoor that lets agencies skip the usual red tape in urgent cases. It all tied back to Loper Bright, the case that just shattered the Chevron Doctrine, ending decades of court deference to federal agencies. Kennedy's point? If a rule is unconstitutional under Loper Bright, the Justice Department shouldn't need excuses to reverse it. They should already know the law doesn't allow it. This wasn't just a legal quiz. It was Kennedy testing their readiness for the bench and their understanding of limits on executive power. And if you listen closely, the answers revealed a lot. If you're tired of legal double talk and want the truth behind these hearings, hit that like button, drop your take in the comments, and subscribe to America Progress Your Home for sharp, no-nonsense political breakdowns.